Well, welcome everybody. My name is Alan Raul. I'm a member of the board of the Society for the Rule of Law and a charter member of that group. We're a membership organization, primarily of conservative and center-right lawyers dedicated to speaking out and defending both democracy and the rule of law. We are a membership organization. We'd be delighted if you're not already a member of Society for the Rule of Law that you would consider joining. There is a link to the Society's website, that's been dropped in the chat. You can visit us at www.societyfortheruleoflaw.org. And so please visit our website and consider joining if you're interested. Also wanted to let you all know that we have a very exciting upcoming in-person event with John Bolton in Washington, D.C. on March 27. Our board president and founding member George Conway will do a conversation with Ambassador Bolton about his experiences, including in the Trump administration and the new preface to his book. The new preface is entitled "The Room Where It Will Happen Again." So you can register for that March 27 in-person event in the evening of March 27. We will have Q&A at the end of our discussion today, about 15 minutes. Please, if you're interested in propounding a question, enter it into the chat, and we'll get to the questions, as many as we can. Keep the questions brief, of course. So I will serve as moderator and introduce the panelists, set the stage a little bit, and then turn it over to our panelists after, and I'll be a brief introduction. Casey Mattox is Vice President for Legal and Judicial Strategy at the Americans for Prosperity Group. He is Vice President for Legal and Judicial Strategy, advocates for a legal system that respects the rule of law and protects individual liberty. Robert, or Bob, Corn-Revere is Chief Counsel at the Foundation for Individual Rights and Expression. Before Bob joined FIRE from the law firm Davis, Wright, and Tremaine, where he was a partner for 20 years, specializing in freedom of expression and communications law. He's regularly identified as a leading First Amendment and media law practitioner. Ori Lev is Special Counsel of Protect Democracy, where he works to defend the rule of law by reducing support for authoritarian factions and building defenses to protect targets from autocratic tactics. So we're here today to discuss in real time, and thank you all to the panelists and audience who are going to be parsing Supreme Court tea leaves pretty much in real time. The oral arguments ended not more than 2-3 hours ago. Just to set the stage a little bit, the issues presented for the court are whether the respondents, namely the government parties, Surgeon General, and other U.S. government officials, the respondents are the petitioners, the state AGs of Missouri, Louisiana, 5 individual plaintiffs, whether they have Article III standing, whether the government's challenged conduct here transformed private social media companies' content moderation decisions into state action and violated the respondents' First Amendment rights, that is to say, the state attorneys general, the 5 individual social media users, and whether, in particular, the terms and breadth of the preliminary injunction ordered by the lower courts was proper. According to the U.S. government, the petitioners, the Fifth Circuit here, found the state action to be taken pursuant to overly malleable, overbroad standards for coercion, and the meaning of significant encouragement leading to a perception of coercive conduct. The court, the Fifth Circuit, applied a 4-factor test developed by some other circuits that included the speaker's word choice and tone, whether the speech was perceived as a threat, the existence of regulatory authority on the part of the government petitioners here, and perhaps most importantly, whether the government conduct referred to adverse consequences for the social media platforms here. The government argued that the lower courts were too subjective, failed to properly respect the government's right to forcefully advocate and defend its own policies, including by using strong language to criticize the admittedly constitutionally protected speech of others. Of course, further complicating all of this, besides ambiguous four-factor standards and the nature of the facts here, is the lurking hyper-partisanship of essentially everything on the internet these days, along with what I'll call a general anomie or breakdown of shared values and even shared factual understandings. So all of this context has led to an imperative, or at least a craving by many, for some content moderation of online speech on social media platforms, and has created seemingly endless opportunities for the Supreme Court to draw lines, create ambiguous balancing tests, and split innumerable digital babies. But fortunately, our expert panel will explain it all in 5 minutes or so each in opening remarks, and then help elaborate and lead to a better understanding of group discussion, followed, as I said, by questions from the audience that you can place in the Q&A channel. So with that, without further ado, Casey, if you'd take it away, and then we'll turn it over to Bob and Ori.
Absolutely. Well, and I have the misfortune of being on a panel with some very smart people that I want to hear from more than I want to talk to. So I'm sort of anxious to get through my remarks to be able to hear what they thought of this argument. But thanks for doing this. Thanks for pulling this together. Obviously, and it'll be interesting to see what everyone's initial reactions are to this case. So this is a very important free speech case, I think, and I think it really speaks to sort of the challenge that we have, not only in applying kind of the bedrock First Amendment principles to the modern versions of those when we're dealing with speech online, social media platforms. There are some odd fits, trying to make the sort of old doctrine fit the new realities of how things work. So this is, I think, a screaming example of that. The other thing that I think is really important in this case, that I keep kind of my framework thinking about this case. I work on free speech issues, but I work on larger sort of structure of government questions. And the thing that keeps coming back to me in this case is that all of the difficulties with this case are really about trying to figure out, how do you craft First Amendment relief in a case like this? How do you craft an injunction that binds the government? And I think all of those really stem from a fundamental problem, that this is really about structure of government questions, at least as it is about the First Amendment questions. When I look at this case, I see reams of federal bureaucrats who were never told that your job is to go contact social media companies and implement what Congress has ordered you to do, with certain standards about what Congress is telling you to go do, right? It's basically free-floating federal bureaucrats who think it's their job to go and be the change they want to see in the world. And they're contacting social media companies and telling them what tweets they want to see them delete, what users they don't want to see on the platforms anymore. And sort of setting aside the First Amendment problems, I've got sort of structural concerns with the way this process works. Justice Scalia, he's been quoted in numerous places saying that the Bill of Rights is not sort of the first place where our freedoms are protected. Every tin-pot dictator had a Bill of Rights, and some of them were a lot better than ours on paper. Where your rights are really protected are in the structure of the Constitution, actually having different branches have to go to war with one another and check and balance one another. And that's what I think is really missing in this case. When you have federal bureaucrats kind of secretly, quietly, behind the scenes communicating, and frankly, having the kind of power that they do, the amount of money and the regulatory power that they're able to bring to bear against these social media companies, all of the questions in this case, and there were a number of them about, well, is it really coercive? Could this person really remove your Section 230 protections, for example, right? Some undersecretary somewhere. Well, no, probably not. But what they could do is make your life a living hell. And if you're a social media company, you've got to take that into consideration. They may not be able to remove your Section 230 protections, but they can definitely make it very difficult on you for a while. So, I think in the terms of the actual, so that's kind of my big broad framing. I look at this through the lens of, you've got the First Amendment question, but you really have this kind of, these structural questions about who is supposed to be making our laws and who's supposed to be simply enforcing those laws, and what are we supposed to be asking them specifically to do in these federal regulatory agencies. And thank God we haven't actually empowered any of these folks to actually be the czars of content moderation online, because as troubling, I think, as some of the facts are in this case, I can't imagine how much worse they would be if you actually had people like the Vulo case, which was the other case that was argued today, where in Vulo you have an insurance commissioner in New York who is specifically tasked with the job of regulating insurance companies. And all of the sort of causation issues that come up in Murthy, I think, are basically eliminated in Vulo, where you have an insurance commissioner who's able to pick up the phone, call the insurance companies, and tell them, here's what I want you to do. And you know that I have direct power over you. So when I tell you to do something, you know what you need to do. So, I think it was a difficult argument, I think, today for the petitioners in Murthy, but I think only because of the fact that you have these questions about how do we solve this question using the First Amendment. I expect that the Vulo case, which came along with it, is going to be an easier question to answer. And I think they'll end up deciding that case under Bantam Books. I think they'll probably craft a rule there that will help to inform how they're going to answer the question in Murthy. But Vulo is the easy path to help them get to the Murthy result.
Great, thank you, Casey. Turn it over to Bob now.
Thanks, Alan. I'd agree with Casey that the importance of this case is really in the broader themes that it raises for various of the cases that are up before the court this term. I think there are sort of a trilogy of paired cases that speak to really fundamental issues. One is the relationship between government and online media. That's one broad theme. And the second theme is, how do you apply First Amendment to things that are not direct regulation, but are either informal or hidden types of regulation? They've come up in the cases involving the use of social media platforms by public officials, the Linkey versus Freed and O'Connor-Ratcliffe versus Garnier, which were argued last October and then decided by the court on Friday. They came up in the net choice cases involving attempts to directly regulate social media platforms by Texas and Florida. And then they came up in today's paired cases, one involving social media and the other not. Murthy, of course, dealing with the jawboning efforts by various agencies in the administration. And then the second case, NRA versus Volo, which involved the insurance commissioner, the director of financial services in New York. The common element is clear right from the beginning, in that the Volo case, the Second Circuit applied the four-factor test, Alan, that you mentioned, and is the one that the Fifth Circuit applied in the Murthy case. So the two cases are really very tightly joined. And I think because of that, and because of the importance of these issues, these cases represent the most, taken together, the most consequential term for First Amendment issues that I've seen since I've been practicing law. Certainly the cases involving the direct regulation of social media platforms are going to set the tone for the regulation of online media and social media. But more to the point, as First Amendment doctrine has been more robust, as it has gotten more definitive, one of the responses by government has been to find ways to achieve its objectives without actually engaging in formal regulation. Why bother having a law if you can simply have someone operating in the background to put pressure on social media platforms to do what you want them to do? And so that's why it's critical that these cases be decided by the court this term and decided together, in that it addresses both the formal regulation of social media platforms by government and also the informal efforts in the background. One point that I think is worth making, and one that we tried to make in the amicus brief that we filed in the Murthy case, in that this is not a partisan issue. As much as the Murthy case is surrounded by this aura of partisanship because of the origins of the case, it really is a question of limiting the government's ability to pressure others into changing their speech, regardless of who is in power at any given time. That's one of the ironies here. The attorneys general who are plaintiffs in the Murthy case regularly exercise this kind of jawboning activity that they claim is one of the worst violations of the First Amendment ever if the Biden administration is doing it, and yet they do it as a routine matter. I think the value of the decision in this case will be, and in the NRA case, will be that it will limit everybody's ability to use these sort of off-the-books background efforts at censorship.
Thank you. Thank you, Bob. Ori, over to you.
Thanks, Alan, and thanks to the Society for the Rule of Law for including me on this panel. Thrilled to be here. Found it to be a fascinating argument this morning. I'll start with the headline from the argument, which I think it seems very unlikely that the Supreme Court is going to affirm the injunction that was issued by the lower court in this case. And the only question in my mind is whether that reversal is based on standing, or whether we're going to get a decision on the merits that might provide some greater clarity and a way forward for the courts as these issues continue to percolate. As I read all the briefs and the lower court decisions and coming into today, I mean, my big takeaway was that I think these questions of when the government crosses the line are very fact and context dependent. And I was pleased to see the Supreme Court pick up on that. And I think that the lower courts in this case did a particularly poor job of dealing with that, and instead wrote with a very broad brush. If you look at the Fifth Circuit opinion that was under review, you have very few instances where there is identified, if any, a specific communication from a specific government actor that resulted in a specific outcome. And instead, you have, government agencies lumped together, the White House, the CDC, the FBI, and an assessment of their speech and whether it was not just coercive and met the four-factor test that Bob referred to, but also significantly encouraged the platforms to take action. And, there's a single sentence on CISA, which is the Cybersecurity Information Agency that provided information from state governments to the platforms. There's a single paragraph on that finds all of their communications coercive, which is shocking. I mean, really, every single time they spoke, it was coercive. And, the FBI, the Fifth Circuit says, their communications were not threatening in tone and did not plainly reference any adverse consequences. But because they're a law enforcement agency, they have an inherent power, and therefore the communications were coercive. And the upshot of that is, anytime the FBI is going to speak to a private party on a matter related to speech, if the party takes action, that was a First Amendment violation. So very broad implications from lower court opinions. And I think it seemed clear that with the possible exceptions of Justice Alito and maybe Justice Thomas was very quiet, I don't think the court's going to buy that. One of the things that I think is really important and also was amplified in the argument today is the importance of government speech. That is how government operates. You know, and Casey, you described this as federal bureaucrats, free floating, be the change you want to see. So I'm a former federal bureaucrat, and you know, these are people who are exercising, making the government run, and they are implementing the elected president's policy positions. And so in this case, for example, the administration very much believed that in the face of the COVID pandemic, it was important for people to get vaccinated and that the vaccines were safe, and they wanted to get that message out. And it is critical that government be able to speak like that. And it's critical that government be able to communicate with media publishers. And I think it's really important to recognize that. It's particularly important, you know, 2024, we're going to come into an election. I think we can expect to see attempts at foreign influence and interference in that election. The government, as is pointed out in the government's brief and the amicus briefs, oftentimes has unique access to information, certainly about things like when are the polls open, when are the polls closed, right? I mean, there was a hypothetical at oral argument today, just countering the most basic factually inaccurate information, which is likely not even protected by the First Amendment, but is going to get lumped in here. The government is uniquely positioned to speak to that, and it's really important that the government be able to speak to that. And I think that's what's lost in these broad brushstrokes of, you know, unfettered bureaucrats run amok, because I don't think that that was what was happening here. And I think you really need to look at the fact. And in the second case, the NRA case that was discussed, you have a small number of facts, and so the court was actually able to focus on each one and say, well, is this coercive? Is this coercive? Together, are they coercive? And one of my things I'm sad about in this oral argument is that we never got to the nuance because of the broad brush. There was very little actual, because of the broad brush and because of the very extreme position that the plaintiffs were putting forth, which was that any communication from the government was impermissible to a platform about speech would be impermissible. We never got to the nuance of when do you cross the line from, hey, I'm giving you information and asking you to act, to now I've put the thumb on my scale too much and I'm forcing you to act effectively, and that is a First Amendment violation. And I recognize very much as I recognize the government interest in speech, I recognize the interest on the other side of not allowing the government to coerce private speakers into censoring speech or compelling speech, right? That is classic anti-democratic playbook. That is how autocratic regimes punish their political opponents. It's particularly concerning when you have an election in which one of the candidates running for office is openly running on a platform of retribution, and that is one of the ways to effectuate retribution. So there are competing interests here, and I think this is a challenging case, and it wasn't, you know, the way to address it, though, is to really dig into the facts. And if we get a ruling on standing or a ruling that doesn't grapple with the nuances of this, then it's a lost opportunity to provide guidance to the lower courts as we go into an era of extreme polarization about how to determine when is that line crossed and when is it not.
Thank you, Ori. And I'd like to picking up from your handicapping of the outcome to see what our other panelists think. I will say I tend to agree with you that they're not going to uphold the Fifth Circuit in any broad manner. This is a case. I was struck by the sympathetic view of so many of the justices who did speak to the government's position, and picking up on what Ori said, there was a clear acknowledgement that the government's speech here and their conduct was very important on major policy matters. I don't know whether it came up in the oral argument or just in the briefs that I refreshed myself on before our session today, but apparently the FBI, the Office of the Director of the National Intelligence, the CISA, the Cybersecurity Agency, has not spoken with any, has not contacted or spoken to any of the platforms since the July ruling. And there seemed to be, by my discernment, a certain anxiety on the part of the justices that the government ability to execute its policies was being inhibited by this ruling. And one of the interesting factors, I think this follows what Ori was suggesting, is that the legal principle here really isn't in doubt, that the government's censorship of private actors is a violation of the First Amendment, but it is intensely fact dependent. And so what sort of one, I'll turn it over to Bob and to Casey. What handicapping do you have of where the court will go, and how the justices will break down? And do you think that they'll take an out of standing here and find that there's no standing, or perhaps that there's no standing for the state attorneys general? Let me, Bob, and then Casey, perhaps you can respond on that.
Yeah, thanks, Alan. First, I want to congratulate Ori on being willing to lead with making a prediction.
Yeah.
I always hate the idea of making predictions after Supreme Court arguments, or at least most Supreme Court arguments, and this one is no exception. I came away, and I'm still not really prepared to make a prediction about how the court is going to come out on it. I would agree with you that the Solicitor General for Louisiana, who presented the argument, did not do a good job of trying to narrow what the injunction should look like, or identify the line between persuasion and coercion, or excessive cooperation. He left the court to grapple with that on its own, and it may well be that the court will try and come up with a test that affirms the Fifth Circuit. Again, I'm not making a prediction here, but I think it's also useful to review where this all started with the district court opinion that I thought was very broad and undisciplined, and in its scope, both being willing to accept pretty much every allegation that contacts between the government and the social media platforms were illegitimate, and the scope of the injunctive relief, which was both hard to understand, both in its scope and in its exceptions. It was really pretty incoherent. So I thought the Fifth Circuit did a decent job of narrowing that, and in applying, oddly enough, the four-factor test that the Second Circuit had articulated in the Volo case, but then applying it, following, taking some instruction from Judge Posner's opinion in Backpage.com versus Dart, to try and focus in on what the injunction should say. Now, I have to say, following what Ori had said, I understand the importance of government speech as a former federal bureaucrat working with the FCC. The kinds of pressure that we're talking about here was referred to as regulation by raised eyebrow. And it was one where, when you work for a federal agency that has the power of life and death over broadcast channels, then if you get the sniffles, broadcasters tend to get a cold. And so those kinds of informal contacts historically led to all kinds of policies that the government would not be able to directly. And that's what this case really focuses on. When does the contact between government and private speakers cross the line? And I don't think you can read the record in this case without being somewhat disturbed about just the extent and level of contacts that there were. And admittedly, these were over critical issues of public policy. And people striving mightily to do a good job, but also getting caught up in the process and believing that if they applied pressure in the right places, they could get social media platforms to essentially adopt the policies and the moderation decisions that they wanted to see. I don't think anyone can look at that and not be at least somewhat disturbed by it, even if you think it's being done for a noble purpose. I think the real threat is if we don't get a definition of where that line is, of going too far, then it'll be too late to confront that when we have an administration that isn't so interested in doing a good job. Let's say, I guess the word retribution was used earlier. When you have this kind of informal power and no judicial check on it, the real question is this the kind of power that you would trust your worst enemy to exercise? And I think that while the fact pattern in the NRA versus Volo is easier to get your mind around, fewer examples, you can focus on it. Here, in the Murthy case, I think the very fact that you're talking about thousands of contacts, you're talking about daily interaction between top executive branch agencies in the White House, and sort of the assumption as a matter of course that the government and this independent private decision maker are going to be teammates working hand in hand, is something that we really need to have a constitutional rule to keep in check.
Yeah.
Thank you, Bob. Casey?
No,
Willing to predict?
yeah, well, in terms of predictions, I predict a splintered court. Does that help? I mean, I think you've got multiple questions here on redressability that came up with several different justices. I will say that one of the parts that I was kind of chuckling at, maybe it's gallows humor at one point in the argument, was the suggestion that that the there's sort of no evidence, suggestion that there's no evidence that the things that government was pressuring social media companies in the past on would continue going forward in the future. And I was thinking, some of those were about the 2020 election. What would cause us to believe that 2024 would simply be a repeat of 2020? I thought, I think we can all be forgiven for looking around and thinking that apparently American politics is capable of repetition right now. So anyway, I think you're going to have redressability. I mean, a lot of concern with the scope of the injunction and just how to work that out. I have no idea how to handicap how that's going to play out, frankly, with the justices. Several were sort of tight-lipped. I thought that one question that I thought was particularly interesting, and I haven't seen much conversation about, was Justice Barrett's question of the principal deputy solicitor for the UN. She asked about the sort of joint action question. When would it be joint action if Facebook decided, look, we've got a real problem here with misinformation about about COVID or whatever the issue is, and we've just decided we need to hand over to you the job of content moderation because you know this stuff better than us. And so we're just going to quietly hand over that power to the government and ask you to moderate our content on this for us.
Yeah.
And the principal deputy solicitor said, well, that would be joint action. That would not be okay. And I thought, I feel like there's a good argument that there's examples of that in this record that are sort of admitted. If you have Facebook already coming to the CDC, for example, and saying, we don't want to have false information about vaccines on our platform, and so we're going to ask the CDC to tell us what's true and what's false. That there's a difference of gradation, but not a fundamental difference between the hypothetical that she asked and what I feel like is in the record, that you had sort of social media platforms deferring to, well, we will not allow information that's false about the vaccines on the platform. The other thing I'll say too, I think this is I think Ori makes a very good point about the sort of desire to do right by some of the government officials that were involved in this case. I think it's we shouldn't assume ill motives or or anything by some of these folks, but the reality is they got it wrong a lot. there were claims about the vaccines that ended up where people were told to take information down that in retrospect, it turns out it wasn't as false as we thought it was at the time, or as the people who were saying, thought it was. The efficacy of vaccines, for example, and the ultimate effect of having a rule where government is stepping in and urging platforms to take information down that's not true. I feel like this is the screaming example of why the First Amendment is so important. Even where they largely got it right. When you have the government stepping in and asking the social media platforms to take down content, all it ends up doing is basically causing people to lose confidence in the process. And I think for a lot of people, they came out of COVID feeling like this wasn't science that we were doing. There wasn't an actual use of expertise because the expertise seemed to be not allowing for any challenge. And that doesn't sound like the scientific method to people. That sounds like there are rules that are being enforced, and I'm not allowed to question the rules. And I think that can be more damaging than allowing false information. And I think that COVID is maybe the best example of where we've seen that play out. So anyway, I'm not sure how this thing is going to resolve, other than that I think that I feel a lot more confident on the Bulo result, and I think it'll help to inform how this one actually plays out.
Yeah, and if I could just pick up on one point that you raised about Justice Barrett's question about joint action, that's one ambiguity in the question that was presented and accepted for the court that I hope will be cleared up. Because as presented by the Surgeon General, the question was, when do social media platforms become state actors when they go along with pressure from the government? And that wasn't the issue below at all. It was when the government becomes excessively cooperative or excessively coercive, or where it engages in significant encouragement that violates the First Amendment. And it's a critical difference, because there were no social media platforms that were defendants in this case. It wasn't that they were becoming state actors. The question was when government crosses the line, either by coercion or by entangling itself into the private editorial process.
Can I make a couple
Go ahead,
points in response to a lot of good stuff there? On the point, I think, Casey, you said that I made the point the government was trying to do right, and that really wasn't the point I was trying to make. What the point I was trying to make is these weren't bureaucrats run amok; they were bureaucrats implementing policy of their elected government, whether that's right or wrong. And I don't think ultimately matters in the First Amendment analysis, because the government doesn't get to be the arbiter of right or wrong. Though I am struck by your characterization of the communications with the CDC, and I think they are the way you painted that portrait is why this is a really hard case. Because the other way to paint that portrait is that there is a once in a century pandemic that's killed hundreds of thousands of Americans, and the government's public health agency, which is one of the preeminent public health agencies in the world, has information, and platforms go to the government and say, we want to know what you, the preeminent public health agency, thinks, and then they make their decisions, right? And that it can't be that they're not allowed to do that, and yet it also shouldn't be that the government gets to compel the platforms to take down what the government doesn't like. I guess the two other points I'd make, and one is, and I can't remember who alluded to this, it might have been you, Alan, is the chilling effect that this case has had, and the fact that the government hasn't been communicating with the platform, and that the House Oversight Committee subpoenas have had a similar chilling effect on researchers into how election, misinformation is spread. There's a real cost on both sides of these issues. And I don't I haven't read the record. I confess it's, the thousands of pages of the record. I'm not familiar with every communication. My point isn't that the government was all, everything the government did was perfect. It's that the broad brush by which the Fifth Circuit, wrote its opinion, even, though it was narrower than the district court, is problematic. The last point I'll raise is, I talked about how the argument didn't really get down into nuance and what will this test ultimately look like. And there's an interesting suggestion in one of the amicus briefs that was is sort of a tie goes against the government point, which was, look, if the test is, does a reasonable person think that the communication is coercive, which is a test the government put forward today, and I think a number on the court were receptive to, then on those really close cases, one party has the power to ensure that the communication isn't coercive, and that's the government, right? It can craft its speech in a way that's less coercive. It can expressly say that its speech isn't coercive. And I don't know that that's the right test, but it really jumped out to me as an interesting way to have a bulwark against, you want a rule that's good for the goose and good for the gander, right? That when your worst enemy is in power, you want that rule to work just as when the person you voted for is in power. And that's a rule that says coercion's a test, but if it's close, we're going to rule against the government because you, government, perfectly have all the power to make clear that your statements are not coercive. So I just throw that out there for consideration. And again, I don't know that it's right, but I was disappointed to see that kind of conversation didn't happen at the oral argument because there was too much other stuff in this case.
That's an excellent point. I would have liked to have seen that point being made, just as I would have liked to have seen more being made of the test that the Fifth Circuit did articulate, right? The question isn't whether or not government and private speakers can't communicate. I mean, one of the examples that was raised is newspapers that are about to run a story that has national security implications will routinely check with their contacts in the government to double check whether or not they believe there's a national security threat before they run it. And that kind of contact isn't the sort of thing that this test would prohibit, right? It doesn't prohibit anyone, and as a private speaker, from reaching out to the government to ask what they think. It bars those kinds of contacts where they talk about the tone and the specific way in which the contact was made, whether it's perceived reasonably as a threat, whether there is some perceived government power, whether it's the exact government power to do some particular threat, like repeal Section 230, right? And those factors do have, I think, a limiting effect. Now, to the extent there has been a chilling effect, and by the way, as a First Amendment litigator, it does my heart good to hear people taking seriously the notion of a chilling effect, because that is central to many of the arguments we make in the First Amendment world all the time. But I have to take the chill since the Fifth Circuit decision with something of a grain of salt, because I have to believe a fair amount of that was strategic. That, when you have this ruling coming down, limiting these kinds of continuing, ongoing contacts between the government, for then people to say, well, I'm not going to talk to you at all. That struck me as being fairly tactical.
Let me ask you a question, Bob. I think it was you who said, if it was another panelist, you're all brilliant and discerning. So forgive me if I got it wrong, but I think it was you who said that a tie should go against the government if it was another one.
Justice Roberts who said that.
Yes, but you pointed it out. I was very struck by the amicus brief submitted by the Reporters Committee for the Freedom of the Press, that I expected to take a different position than the one that it did. It's brief. It quoting Max Frankel, a former Washington bureau chief of the New York Times and the Pentagon Papers. It describes the relationship between the government and the free press in this country as, quote, cooperative, competitive, antagonistic, and arcane. And the Reporters Committee for Freedom of the Press says that, of course, as you all have said, and as we've noted, this case implicates intensely fact-sensitive issues in the balance of the First Amendment given these dynamics between the government. But what the Reporters Committee invited the court not to do was to set a hair trigger standard for that would chill the ordinary and necessary flow of information from the government and with other parties. The Reporters Committee said that if these conversations, these communications are, if the standard is too strict and the dynamics of the exchange of information are if the standards would constrain and chill the speech, that would end up eviscerating the press's own right to exercise editorial control over speech and speakers on their properties and platforms. So basically, the Reporters Committee is saying, don't let the standard be so narrow that it is going to constrain and chill the speech of the government reaching out to the private parties. Do you have any reactions to that? If you saw that brief, there were a lot of briefs here, but did it surprise you as it did me that was their position on free speech?
No, it didn't surprise me, and I think it speaks to the example I was mentioning earlier of where you have members of the established press who will interact with government in various different contexts. Part of it is just part of the ongoing business of news gathering, and part of it is to check against whether or not a story is going to have some kind of adverse impact, and then making an editorial judgment about how to handle that. I can understand if the standard is set too strictly that you're just saying government and private editorial decision makers can't speak, that would be a problem. But I don't see that as being the result of what the Fifth Circuit decided here. And I think, and as several of the justices pointed out during the argument today, that we are talking about a unique context in which you're talking about a medium that has just billions of posts that if you have continuing contact with the government over what their overall moderation policies are going to be, that presents a different kind of question.
Great. Let me just
can I just add one comment on that? And I think part of the problem today was that the Attorney General did not articulate any standard. The Attorney General essentially, when asked the hypothetical of the Washington Post, getting the call saying, please don't publish it, it's going to harm our troops, he sort of said, well, that would be okay, but he couldn't articulate why. And when pressed at other times, he said, anytime the government asks an editorial board to not publish something, that is a First Amendment problem. And that's not a workable standard for the reasons that you just articulated, Alan, from the Reporters Committee case. And so there wasn't really anything on the other side being proffered other than the four-factor test.
I think there was, I understood him to be saying in that specific example that strict scrutiny was the answer, that you may be able to pass strict scrutiny when you're talking about, troop movements or true national security concerns, but that basically needs to be the test that you're operating under.
Well, he was sort of, yes, Justice Jackson had this strict scrutiny line of thinking, and he did ultimately fall back on that. I agree, but that didn't feel like the flavor of his affirmative argument throughout the morning. That was more reactive to her suggestion, I thought.
I will say, I think kind of more broadly on this chilling effect thing. One, I agree with Bob that I'm dubious about this notion of the government truly being chilled. But if it is, fantastic. I am quite a fan of the idea of the government having a little bit of chill. The government hasn't emit the powerful side in this conversation.
Let me ask you a question, Casey. Do you feel the same way in that regard about chilling the government is good with regard to terrorist speech, criminal activity, national security, as you do on, let's say, COVID and election interference, perhaps?
Yeah, look, and let me be very clear. I'm vaccinated. I'm vaccinated and boosted and everything else, right? So this is not a question of do I agree with the government's position or with, and as far as I can tell, I believe that some of the some of the facts in this case, this was a multi-administration issue. There were and any injunction would carry forward in an official capacity and would affect a future Surgeon General just as much as it would the current Surgeon General.
And
Yeah, I think there's, go ahead, Bob.
So I think there's, sorry, go ahead.
Oh, finish your thought. I'm sorry.
Yeah, no, so I think it's just, I think that the reality is the government is very powerful. It's going to get its voice. It's going to be able to communicate what it wants to communicate. I think if nothing else out of a case like this, if the government has to have a shot across its bow to think, okay, am I overstepping my lines here? Are there lines that need to be that I need to be cognizant of in the first place? I think that's a positive thing. And if we describe that as chill, that the government is thinking maybe we should back up from the constant communication with social media platforms. I think the reality is the reason they weren't communicating so much about COVID misinformation the last few years is twofold. One, COVID is less of a thing than it was, at the very beginning of this case when many of these facts were coming out. And then secondly, I think hopefully a little bit of honest, okay, well, the things we were telling people before were false about COVID or vaccines. We've got a little bit more nuance in that now. And so maybe we would have demanded that things be removed before, that maybe we wouldn't demand they be removed now. And so maybe we should have a bit more humility about this than we had in the past. If that's chill or if that's just growth, I think regardless, it's a positive thing for government to have at least a little bit of, maybe I should check myself a little bit here before we push forward with urging people to remove.
Can I ask a question for all of you? And we're getting close to the end. I'm not looking in the right place, or I'm not seeing any audience questions. But let me ask you, as has been noted, the platforms, the social media companies, they were not parties here. They're not defendants. Perhaps their views are expressed by the amicus brief of NetChoice. But what I like others perhaps on the call have not poured over the administrative record, the factual record that was established, the evidentiary record for a preliminary injunction. But there was opportunity for discovery in the case that was brought out at oral argument. Why is it that the position of the platforms as to whether or not they were coerced was not elicited effectively in apparently any way, because it was not argued at the hearing and it was not in the briefs, although there were questions about how relevant is it that their decision-making authority and that their judgment wasn't overridden by the government. But isn't it critical here to understand factually whether the platforms were objectively coerced by bringing out evidence as part of the preliminary injunction standards for making a factual case of irreparable injury? So with that, let me turn it all over to you. And we did have a question: what is the four-factor test? I think I did articulate that at the beginning, and we've addressed it, I think, in the various comments. We're getting very close to the end here. So let me turn it over in reverse order of the way we began. Ori, Bob, and then Casey to make a final comment in about a minute or so. And then I'll take it back and make some concluding thoughts. So, Ori.
Yeah, so to your last question, Alan, I think it's a really good question about evidence from the social media companies. I will say between oral argument and the beginning of this webinar, I was reading the Washington Post, and there was a column there about the then head of Twitter content moderation saying, I wasn't coerced, and we rejected a lot of what they asked us to do, for whatever that's worth. two points. I do think that these are challenging cases, and I don't think they're as black and white as my esteemed colleagues make them out to be, and that there are interests on both sides here. And my last point will be that, however these are decided, the social media companies play a critical role in the information ecosystem, and they do content moderation, and we encourage them to do content moderation. And Protect Democracy just put out a little primer on some recommendations of what we think they should be doing in this election year with respect to content moderation. And set aside whether the government is speaking to them or not, they have a critical role to play here.
Great, thank you, Bob.
I would just sort of echo what I said earlier about refusing to make any predictions, and just say that it really is going to be critical for the court to draw some lines here. I agree that the advocates could have done a better job of helping the court in trying to define where the limits are, both of excessive coercion and too much entanglement in the decision-making process, and that the answer that it comes up with is going to be critical for whoever happens to be in power at a given time. I worked with Protect Democracy when we sued the Trump administration on behalf of PEN America. And then it was over, again, the kind of informal pressure being placed on media companies and on particular reporters. And I think the same principles apply here, and also apply to the attorney generals who brought this case. So I'm looking forward to a decision. I'm hoping the court is able to bring more clarity than we saw this morning during the argument. And I'll be eagerly awaiting that decision.
Thank you. Casey, last thoughts?
Yeah, this is by no means do I think this is an easy case. I think it's a very important case, and it's obviously a very complicated case. But I think it's complicated because of the very fact, and this kind of connects to your question about whether we need sort of the testimony or the proof from the social media companies they've been coerced. I think part of the very challenge with how to understand coercion in a case like this is at play there, because realistically you're talking about multi-hundred-billion-dollar corporations that have a lot of interests in front of the federal government. So the idea that they would volunteer that, yes, those very government officials that I am dependent upon for a merger that we're trying to get through out of the FTC, they coerced me. And I say that just to try to get it's unlikely, right? So I think there's it's a complicated case, and this is where go back to the very beginning of my remarks. I think it speaks to we have this sort of modern administrative state that has a lot of power, and it's difficult to try to figure out how to put that reality together with the test from Bantam Books in a very different context, and different kind of power over the intermediary there. I do hope we get some clarity out of the court. I'll be surprised if we get the level of clarity that will make me and Bob happy. So,
well, thank you.
And to me.
And you.
Oh, and to you. Oh my God.
Level
Yes.
of clarity. I'm into that.
Yeah. No, that's right. That's right.
So thank you. I am going to go out on a limb. I think that the justices, to me, they sounded like they were looking for common ground with each other, and to avoid, even though the discussion, the oral argument, the briefs were not postured in a partisan manner. I think the partisan overtones, as was mentioned by many of you and myself. I think it is in the environment here, in the atmosphere about what this case, even though what's good for the goose, or what bad for the goose is bad for the gander, the administration can change, and the justices will surely recognize that the government must proceed. And I think they may find ways to be sympathetic to the government responsibilities here, scale back the injunction, find some common ground. It may be splintered rationales, but try to find some common ground. I know that I'm not going out on a limb when I thank each of you, each of our great panelists, for jumping into talking about an oral argument that took place just a couple of hours ago and doing it so eloquently and incisively. So thank you for doing that. Thank you to the audience for joining us. Please think about attending the John Bolton event with George Conway on March 27th. And if you're interested in joining and following the activities of the Society for the Rule of Law, at the URL that was just placed in the chat, www.societyfortheruleoflaw.org. And with that, I can declare us adjourned. Thank you all very much.